Beal Properties versus Melissa Daly.
Good afternoon, Your Honor. Jim McCarroll on behalf of Beal Properties.
Judge Dominic Camden appearing on behalf of Melissa Daly.
Before this case even begins, understand what we're walking into. This is not one simple eviction hearing. This is two separate housing battles packed into one courtroom stretch, and both of them show how messy landlord-tenant court can get when legal deadlines collide with real-life emergencies. First, Judge Simpson hears from Beau Properties against Melissa Daly, where the tenant is absent because her attorney says she is undergoing a heart procedure. But on the other side, the landlord says, wait a second, there was already a consent order. She was supposed to be out by April 1st, and she's still there. That means the judge has to balance compassion with enforcement. Then the courtroom shifts into an even heavier case, a family of 7, unpaid rent, housing assistance, limited funding, and a landlord trying to recover possession. So the big question becomes, when the law says one thing, but the human reality is much more complicated, how far should the court bend before it finally says, enough is enough?
Go ahead. Judge, there was a consent order that was issued maybe a month and a half ago. Client filed paperwork, not through my office, initially indicating that she was having some medical issues. I appeared
regarding the move out.
Plaintiff's counsel understandably was not there because I don't think my client served them. So I'm not taking any issue with that at all. Subsequent to that, the plaintiff's counsel filed the actual writ to evict my client, and the court set it for hearing today. I can tell the court that I got notification from my client of today's hearing. I didn't come directly from the courthouse, which, okay. But my client did inform me that she's having a heart procedure that started she had to be at the hospital at 7 a.m. She basically had told me she had been waiting for the appointment, and there was an appointment that opened, and I instructed my client that she needed to keep her appointment because, with all due respect to this court, her health took precedence, and I'll fill the gap in for her. But her procedure was today.
Okay.
Well, Your Honor, insofar as the appearance here, I certainly have no truck with that. But there was an order that said that the defendants were going to vacate by April 1st. They did not. That order was entered in February. They had a month and a half to effectuate what they were supposed to do, and they continue to occupy the property. My client understandably wants possession of the property, and that's why we're here today.
Do we have any verification that this procedure is taking place?
I have an email, Judge,
from her, but nothing.
I did not ask for any verification from the doctor's office, Judge.
No rent is being paid, right?
Correct. She was a Section 8.
Section 8 been terminated?
It has been terminated, Your Honor. I'm just told by my client that the debt is up to $50,000 at this point.
That number changes the entire temperature of the room. Up until this moment, this sounded like a procedural issue. A tenant missed court because of a medical procedure, the attorney is asking for some understanding, and maybe everyone can come back next week. But then the landlord's side drops the alleged debt, up to $50,000. That is not a small arrearage. That is a full-blown financial crisis. And notice how Judge Simpson immediately has to start sorting through competing realities. On one side, the tenant may have a legitimate health emergency. On the other side, the landlord is saying rent is not being paid, Section 8 has been terminated, and possession has already been delayed past the agreed move-out date. This is where eviction court becomes brutal. Nobody's situation is simple, but the property owner is also not required to provide endless free housing. Would you give the tenant more time here, or enforce the prior order?
Yes, Your Honor.
I mean, we're going to get into, maybe we need to get into but there's some question about whether it was terminated correctly, who was necessarily caused it to basically be lapsed, which was the basis for the counter complaint that was filed in this case. Essentially, the reason why the parties agreed to dismiss it without prejudice.
So you're indicating you want to raise the initial issues that were subject to the dismissal.
If we could approach.
Yeah. Record in this case was down for case. This is regarding the issuance of the writ in this matter. Mr. Hampton was gracious enough to share with myself and counsel the email that was sent. The nature, I don't know the entire nature of the procedure that the defendant is undergoing. However, one thing that is stated in there that shed some light for the court is that she indicates to be available next week. I'm not going to adjourn it to next week because I don't know that there's really an issue ultimately that this court is going to come to. So I'm going to issue the writ, but delay its execution and indicate that it can be executed no earlier than the 29th.
This is Judge Simpson threading the needle. He is not fully reopening the case, and he is not simply ignoring the tenant's medical situation either. What he does is issue the writ, meaning the legal process for restoring possession to the landlord is moving forward, but he delays execution until no earlier than the 29th. That is an important legal distinction. The landlord gets the court order they came for, but the tenant gets a short window before actual enforcement can happen. It is basically the judge saying, I hear the medical issue, but I also see the prior order, the unpaid rent, and the fact that this cannot keep floating forever. And then he makes the tone very clear. By the end of the month, this is meant to be finished. That little joke about wishing things in life were final is funny, but underneath it, the court is making a serious point. Final orders have to mean something.
All right. So that way she's got to the end of the month and she's done. Counsel posed a good question that is to trying to make sure that it's final. I wish a lot of things in my life were final. If somebody comes in and says something, I think I'm obligated to listen, but the intent of the court in doing this is that this is it. It's done. We're one or two ways it's going to happen at the end of this month. Right.
Thank you, Judge.
All right. Thank you. Beal Properties versus Lieutenant Patrick.
Okay, now doing the part on behalf of Beal Properties.
Your name? Your name, sir?
Matata Patrick.
All right. Well, where are we on this case?
Your Honor, the rent to retain is $2,980.32 with costs of $176.32 for a total of $3,162.64. We're asking for a writ date of May 18th.
All right. Anybody? Yes. Your position with this is you can restate it for the record. Your position with this case? Yes. Okay. So what were you going to tell me?
So there's correspondence with the actual homeowner that there's an agreement where we would continue to pay the rent that we've been paying. In addition to the utility bills that I do a utility allowance for, which were done on yesterday, as a matter of fact. And then we would continue to seek alternate funding for the back rent, as well as find Mr. Matata a new unit to go to. And then my agency could then, if we couldn't seek an alternate community resource to pay for his back rent or pay a portion of that, we could then pay that entire back rent at that point once he leaves the unit. And that's in correspondence. There's an entire email thread with that the previous attorney should have access to. The one that was here a week ago.
All right. So
That's all I believe the name was.
yeah. So what's really happening is the rent's going to be paid going forward.
It has been for the last 2 months. We've paid 2 payments already of $17.60, plus have done 2 utility allowances for Mr. Matata as well.
So what months would those be?
It was March and it was April, and then I just delivered one. Yes. Wednesday, maybe Tuesday, Wednesday. It was a little late because our printing machine was down. I delivered it to the new address on Michigan Avenue in the Dropbox.
So that payment must not have been taken off of this account. And the only reason I'm saying that is because the number claimed owed went up 1 month. But if what you're indicating happened, then it's going to go back to that one figure where I have a static amount of back rent.
Now the second case becomes a math problem, a housing problem, and a paperwork problem all at once. The agency representative is saying rent has actually been paid going forward, including 2 payments and utility allowances. but the amount claimed by the landlord appears to have gone up, which makes Judge Simpson pause. That matters because in eviction court, the exact number is everything. If ongoing rent is being paid, then the issue is not a growing monthly default, it becomes a fixed back rent balance. That changes the entire strategy. A static balance means the parties might be able to negotiate, seek funding, or create a conditional dismissal. A growing balance means the case is getting worse every month. So Judge Simpson is basically trying to figure out, are we dealing with someone who cannot pay at all, or someone whose current rent is covered, but who is trapped under old debt? That difference is huge.
Okay,
Correct.
all right. No, that's okay. So what are we gonna do then? On the case, I get that rent's being paid going forward, but I don't know.
And the homeowner, I'm not sure, I assumed there was correspondence with them. He had agreed, he said, put it in letterhead, which I attached to the email as he suggested with the terms, so I'm not exactly sure.
Was, go ahead, yeah.
Your Honor, my client has indicated that what he is willing to accept as a conditional dismissal with the terms that have been laid out before the court.
Okay, I guess I don't have a problem with it, but I don't want to end up as the one thing that I didn't hear. Is there a date that he's going to move, or has that been resolved?
For alternate housing right now.
Okay, that's gonna be right. No, I get it. I guess that's gonna be my problem with the conditional dismissal because there isn't an end.
Well,
Oh, and
I would raise the question then, is there a reasonable expectation he'd be out by the end of June? Because we put at the end of June date in there. If not, then we're back to the question you posed, Your Honor.
yeah, but I don't know if that's realistic under. I mean, I can't force somebody to agree to that date. It sounds to me like the parties are working together so that everything stays static. The one thing that's missing is that end date. And how many people are in his family? Do you know? Is it just him?
So
That's gonna be, okay. Now I understand. That's gonna be the problem, because you gotta find a unit for 7.
This is the moment the case stops being abstract. Before this, everyone is talking about balances, grants, conditional dismissals, utility allowances, and move-out dates. Then the judge asks how many people are in the household, and the answer is 7. Suddenly the problem becomes much clearer. Finding housing for one person is hard enough. Finding a unit for a family of 7 with no income, existing arrears, and limited assistance funding, that is a completely different mountain to climb. Judge Simpson immediately recognizes why a simple, move out by June date may not be realistic. And this is where the tension gets real. The landlord has a right to possession and payment, but the family needs somewhere to actually go. Courts can sign orders, but orders do not magically create affordable housing. So here's the question for viewers. Should the court prioritize the landlord's timeline, or give the family more time because the housing search is unusually difficult?
and the family has no income, so that's been the issue, accumulating late fees, and there have been some fees that have been attached that our grant could not cover, so I've had to find, for the last several years, we've been working with him, community resources to cover these fees. And at this point, we've just ran out of funding for those resources. He's access to the ESG funding through SOS several weeks ago, which was the max at that point. And so we've met that for the year already.
So he's already gone through SOS, got the 3.
Correct. My agency, though, I was confirmed with my supervisor on Thursday. We're getting some additional funding for housing in June. What that looks like, I'm not entirely sure. We could put some of that funding towards that balance at that
Is this
point.
coming from the county?
No, sir, I'm not sure what the funding is. If it's
Okay.
grant or.
Gotcha. Okay, no, the only reason I'm asking is because everything is now messed up with funding
Yeah.
in a big way. So let me ask this. If the back balance got paid, are they going to be able to stay or no? I mean,
Our client indicates yes, Judge.
okay.
My rent, unfortunately, we can't pay that back rent until he's out of the unit.
Because nobody wants to make my life easy. Okay.
Client indicates, Judge, if the court is comfortable with putting either a July or an August date to give them more time, we could put that in the conditional dismissal if the court is comfortable with it.
I'd be comfortable with this because we could do that so that there's a conditional dismissal of August, but that there would be no writ without a hearing. I don't, and here's the reason I'm saying that. The issue with what's now happened with funding in this county is my head is still about to explode from a Wednesday morning meeting that I had regarding that. Because the amount of funding lessening as we go into the summer to save people's housing. So normally under the circumstance, we'd be able, quite frankly, if we were in the winter, which is another weird thing, we'd likely be able to find funding to pay this back balance and then move forward. I can tell you right now, it's not going to happen. In particular, if he's already tapped into the resources, it's not going to happen. So I don't have a problem, and I'd appreciate if there was an August date, but that there be a hearing prior to the issuance of that. But as a part of that conditional dismissal, his current monthly rent has to be paid forward so that this amount doesn't get higher.
This is the core compromise of the entire second case. Judge Simpson is willing to give more time, possibly until the end of August, but there is a condition. Current rent has to keep getting paid. That is the legal pressure point. The court is not wiping away the balance, and it is not giving unlimited delay. Instead, it is freezing the damage. If the back rent is already a problem, the judge does not want that number climbing higher while everyone searches for housing or funding. This is why conditional dismissals are so important in landlord-tenant court. They give both sides a structured path. The tenant gets time, the landlord gets enforceable terms, and the court keeps control if something breaks down. But Simpson also adds another protection: no writ without a hearing. That means the family would not just be removed automatically at the end of August without the court taking another look.
So that's what we've agreed to.
Okay. Then I don't have a problem if we do an August date, but there'd have to be a hearing. And again, it's just because we're in so much flux. He's got to find a place for 7 people. But I'd be comfortable doing that. Would that work for you, sir? All right. So
So we'd have an end date of end of August, and there would by necessity be a hearing prior to the issuance of the writ.
correct.
Okay, I'll get that drafted and filed.
All right. So I'll mark this conditionally dismissed and then submit the paperwork to me. Sir, I do have to advise you that you're appearing here, you're not represented by counsel. Once you sign on to the conditional order dismissal, and I think it's clear what has to happen. They're going to be paying your rent. Got that? Going forward, so there's no balance. And then they're going to be looking for housing for you, but nothing would happen until August. You understand that? All right. And then should you not have secured housing by August, there would be a hearing before this court before an issuance of the writ. You understand that? Those are the basic terms.
Okay.
All right. And so since you're unrepresented by counsel, once you sign off on that, you have 3 business days from the date of my signature to move this court to set that aside. Believe that there's some confusion on your part, some misrepresentation, something you didn't understand, or some right you didn't assert. Okay, that doesn't mean I would grant it, but you'd have that time frame. Got it? Okay. Thank you, folks.
By the end of this hearing, Judge Simpson has handled 2 very different eviction disputes with the same basic approach: enforce the law, but leave room for reality. In the first case, the tenant's medical procedure did not stop the writ from being issued, but it did delay execution until the end of the month. That gave the landlord legal movement while still acknowledging the tenant's health situation. In the second case, the court approved a conditional dismissal framework that gave a family of 7 more time, required current rent to keep being paid, and protected the unrepresented tenant by explaining his right to challenge the order within 3 business days. The broader takeaway is clear. Eviction court is not just about rent numbers, it is about deadlines, funding gaps, paperwork, family stability, and whether both sides can live with a structured compromise. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.